Hi, my name is Sumasri, and today I'm going to tell you in brief about the concept of substantial similarity in corporate infringement cases. According to corporate law, substantial similarity explains briefly about a strong correspondence between a corporated work and an alleged infringement, whereby it develops a speculation of prescribed copying. The criteria for proving substantial similarity is whether an ordinary person would presume that the alleged infringement has appropriated non-tribal measures of a corporated work's expression. Copyright infringement is an exclusive violation of rights of copyright holder. In case of any corporate infringement, the plaintiff, the party who instates the lawsuit, must demonstrate that the defendants, the person against whom the lawsuit or the claim is produced in the court, the work is substantially similar to the plaintiff's work. Consequently, the infringement test allows two important components as questions that are to be answered. Firstly, did the defendant copy plaintiff's work? Along with the second question, which involves whether the copied element would defend the expression and is adequately significant to be actionable. In other words, the test intends to resolve if the copying aggregates any infringement. To establish corporate infringement, the infringer shall have admittance to plaintiff's work. In such circumstances, access means whether the infringer had a proper opportunity to witness the original work or not. Actually, while preparing infringement, the court often analyzes all possible details of both the works produced by the plaintiff and the defendant and eliminate all the public domain elements from work and consider only the essential elements that are protectable. Hence, in building the protectable elements, the court would discriminate between the idea sustaining the work created and its expression. In practice, a plaintiff expresses substantial or probative similarity and also infringement by examining the suspect copies side by side against the authentic original. Although it is frequently better to correlate against the original sustained on the file or at the register of copyrights, it is not mandatory that an authentic duplicate of the original work will serve. In a case of Cameron Indus versus Mother's work, substantial similarity is considered to be appropriate test for infringement. It is also called the ordinary observer test, whereby it determines whether an average lay observer would recognize the alleged copy as having been appropriate from a copyrighted work. As we have observed, this theory cannot be applied adequately to conclude infringement firstly, because it repudiates the expert testimony and interpretation necessary to decide if copying can be inferred. Secondly, it serves to blur the line between defenseless idea and defended expression. And thirdly, it does not explain whether the similarity is substantial. That is, do we use audience confusion or some other measures to draw to the benefit of material being used? Notwithstanding years of attempts to define and clarify this concept of substantial similarity, it endures a confusion and unhelpful concept which authorizes courts to observe the real motivations behind their decision. Do let us know what are your views regarding this doctrine of substantial similarity. Thank you.